coming. It's a wonderful evening. And I'm so excited to share with you guys about the Dobbs case, this case that we've been working on, and what has been happening at the Supreme Court. The Dobbs case is just huge. It's just like mind-blowing huge. It is just so significant. It's hard to put into words. It's probably the most significant Supreme Court case ever. Certainly, I can't think of a case that's had more at stake than this one. And so, it's really been an exciting thing to have some involvement with it. The day Lori and I, we were there in D.C. for the oral arguments at the Supreme Court, and it was really extraordinary. I wish all of you would have been there with us. It was really just an incredible thing. And it's something I want to get to it. I want to tell you about it, but I think I need to start really by telling you about the Dobbs case. So I'm sort of referring to it. So let me give you some backdrop, some context as to what this thing was about, why I think it was such a significant case, why I believe it could be the most significant Supreme Court case ever. Dobbs is a case that came from my home state of Mississippi. It's a case involving a law that prescribes abortions at 15-week gestation. Really, when you think about it, a very reasonable law, a very reasonable regulation. However, that law comes within the crosshairs of Roe versus Wade because it cannot be reconciled with Roe versus Wade. And that was really very much part of the thinking when the legislature in Mississippi passed it. And as expected, it was challenged. A group called Jackson's Women's Health Organization, the owner of the last remaining abortion clinic in the state of Mississippi, they challenged the law, and as expected, the district court struck the rule down. And this decision was affirmed by the appellate court, which was the Fifth Circuit Court of Appeals. And they sought cert at the Supreme Court, but the odds of getting a Supreme Court to consider an appellate decision, the odds are very, very low. It's like 1% to 2% of all cases are considered by the Supreme Court. So this looked like the end of the road. This looked like this will be just another reasonable abortion regulation going to the trash heap. But not this day. Not this day. The Supreme Court accepted cert. They agreed to review the case, which was just amazing. It was just amazing. When I heard the news, I couldn't believe it. But I had to temper my excitement because just because the Supreme Court agrees to review the case doesn't mean it agrees to reverse the case. And what that meant is that pro-life groups, legal groups like CRE, we need to roll up our sleeves and get to work. The state of Mississippi reached out to various different groups because they needed help. They needed amicus help for this. Amicus brief it's a friend of the court. And the reason why it's so critical at the Supreme Court level is because the parties have word limits in their own briefs. And so they can't cover everything in their briefs. And they necessarily need others to come alongside and try to fill in the gaps. And they asked us to come along, and I didn't take very long in deciding to help. It was really an honor and a privilege to be part of this. So we talked to this lawyer who was really overseeing the amicus efforts and coordinating with the AG's office to make sure nobody was stepping on each other's toes. And so we talked to him about how can we help, what can we do? And what we landed on is a really needed another voice to speak to one of the doctrines, the legal doctrines that is in Roe versus Wade called the viability rule. And this is basically a rule how they determine when a state would have interest in unborn life. And in Roe versus Wade, they say, well, the state really doesn't have an interest, therefore it doesn't have a say-so, therefore it doesn't have any ability to regulate until the third trimester. And at that time, in 1973, that's when they figured that's when a baby could be viable, could live outside the mother's womb. And so that's what we took on, and it's really easy to take on because the viability rule was a bad rule, is an arbitrary rule from its very creation. For one, it moves. It's where while in 1973, yeah, it was the beginning of the third trimester, but I just read the other day that a couple of weeks ago, a baby was born 21 weeks, 1 day. So you have a moving rule here. But really more importantly is viability has no direct connection to the state's interest. The state is interested in the unborn life. It's interested in life. It's interested in protecting that life, not whether the baby's viable or not. And so that's something we really focused in on in the amicus brief is really how the disconnect disserved the state's interest. And the state has an interest in protecting life. It ought to be able to speak into it. And particularly in dealing with Mississippi's law, shouldn't it be when life can be detected? When can life be detected? And with Mississippi at 15 weeks, life can certainly be detected. Every vital organ is working at that point. Baby can sense stimuli at that point, at 15 weeks. And so those are sure signs of life. But also going back at 6 weeks, you can detect a heartbeat, really a very sure sign of life. And for that matter, at conception, you have DNA, the very blueprint of life, present. So with all these existence of life, shouldn't the state have interest? Shouldn't it have some say-so rather than viability? So that was our argument. That's what we presented to the Supreme Court, along with many other amicus briefs and the state firing on all engines, trying to do something about Roe versus Wade and try to see what we can do about this issue of abortion. All right, so fast forward to last week, December 1, 2021. And this is the day of the oral argument. And Lori and I, we went out early. We went out to the Supreme Court because they had a pro-life rally going on that morning. And it was a wild scene. It was a crazy scene out there. You had people all over the place. And it was heartwarming. I mean, it really was because people were so excited. They were so happy. They were just ecstatic about the prospect that, hey, could this be the case? Could this be the time when we finally see an end to abortion? Just a lot of optimism, a lot of positive energy. And Lori and I were talking about it was really to be contrasted, and it was contrasted with there was a pro-choice rally that was taking place directly beside the pro-life rally. It is within a couple of feet of each other, where the pro-life rally was on the right side, the pro-choice rally was on the left side, and there was definitely I think even if you didn't know much about the issue or really even care about the issue, I think you could probably detect some difference in sort of the tenor. While with the pro-life rally, it was very positive, really spoke about preserving life, helping women, and really loving others, including those who disagree. What you saw from the pro-choice side was really a lot of anger and I think some hurt. They were literally yelling about being prideful about abortions. And so it's interesting seeing that contrast, but as Lori observed, and I agree, is it was really the epitome of free speech, because every side had their say, everyone had their say, right there at the steps of the U.S. Supreme Court. So we experienced that, but then I left early because I had to get ready to listen to the arguments. I'd really hoped that I'd be able to get into the Supreme Court building itself, and that's what we did last time. We did an amicus brief. We were able to go inside the court building, but due to COVID protocols, the only lawyers that could go in the building were the lawyers who were arguing the case. So we couldn't go in, so I tried to find a quiet place where I could listen, and I did, and I just took copious notes and listened to the arguments and tried to pick up on what was being said, and I'll tell you, I was extremely encouraged by what I heard. The case was not decided on December 1st. It was not decided on the oral arguments. That you will not hear a decision until June of next year. But you can really pick up on what the justices are thinking by listening to their questions. My friend Sam, he listens to a lot of Supreme Court arguments, and so he'll tell you that you can really, even though they're asking questions, a lot of times it's not really questions. They're saying things, they're making statements, and perhaps they're using questions to try to convince others on the court. And so the questions themselves can really give you some keen insights. And I think that's what we were able to glean from the oral arguments the other day, is that you could really get some insights from it. So going into it, what it is, if you have a Supreme Court case, because there's 9 justices, it's really about math. You need 5. You have to get 5 justices to rule in the way that you're seeking. And so the question here is, well, do we have 5 justices who are willing to overrule Roe or severely undermine it? And I think we can say with a good deal of optimism, I think we do. I think we do. I don't want to be presumptuous in that regard, because anything can happen. There's some time between now and June when opinion comes out. But just based on what I heard, I think we have a lot of room for optimism. A lot of Supreme Court observers would tell you, and I tend to agree with this breakdown, is that it's really, with this particular issue, you have 3 justices who are firmly in support of Roe. That would be Justices Kagan, Sotomayor, and Justice Breyer. Then you would have 3 justices who really oppose Roe versus Wade. And they have made their feelings known in this regard. That'd be Justice Thomas, Justice Alito, and to a lesser extent, but still I think fairly committed, is Justice Gorsuch. And so really what it comes down to, for an issue of literal life and death, are 3 individuals. And how do they see this particular issue? And that is the Chief Justice, Justice Roberts, and also Justice Barrett and Justice Kavanaugh. And so I listened carefully throughout the whole argument, and then I talked to a lot of other lawyers who were doing amicus and those involved in the AG office about what they heard. And I think a lot of us heard the same, where you had a lot of comments that were expected, but we all perked up our ears when we were those 3, because those 3 will likely decide it. Chief Justice Roberts, what he said, and you could tell by his questioning that he was very concerned about the viability rule. He's not a fan of it. Doesn't think it's really workable, and really sees it for the arbitrary rule that it is, and seemed to be in support of Mississippi's law and saw no reason really to strike it down. That was greatly encouraging. I really did not know what to expect of the Chief Justice on this point, and so that was really encouraging to hear. But the justice that went even further, and I thought had probably some of the more poignant comments throughout the whole argument, was Justice Kavanaugh, where he talked about how the U.S. Constitution is silent on the issue of abortion. It's not pro-choice, it's not pro-life. It's silent on the matter, such that, in what I think the question he was begging there, is that should the Supreme Court even be involved in the abortion business? Shouldn't this be something that the states the people decide. And it was really heartening to hear those comments from him. Justice Barrett, she was a little bit more opaque than her colleagues. I couldn't quite get as good a sense from her, but still she had some questions that definitely indicated that she had some serious concerns about Roe versus Wade, particularly, and I thought this was very interesting how she phrased her questions, dealt with the supposed burden on women as far as having to be a parent. That's what she really focused on, and what she referenced was safe haven laws that really help facilitate adoption. And doesn't that really deal with the burden in that regard? And so from hearing those three and then trying to piece the thing together, I think we do have good reason to be encouraged. Where it seems that by the head count, reading the tea leaves, that we have 5 and most likely 6 justices who will say the viability rule has to go. We've had it since Roe versus Wade, but no more. And let's allow the states to have a greater interest in unborn life. And if that happens, which at this point appears to be the case, that would be incredible. It would be a decision that would literally save countless lives. But also, even more encouraging, something that is on the table that I didn't necessarily expect until I heard Justice Kavanaugh, is that it seems like we could quite possibly have 5 justices who would just come out and say, you know what, there is no constitutional right to an abortion, and we need to leave it completely up to the states to consider this matter, and we're not going to consider abortion anymore. And if that happens, that will be a major step for our country putting an end to this barbaric practice. And so I was very encouraged by it. I'm excited about it. I'm anxiously awaiting what happens in June. So we'll just have to pray for that, and I would encourage you to pray for that. And I want to take this time to thank you. And where Lori and I were able to enjoy that event, and the reason why I would love to have all y'all with us is because we really could not be involved in this case. We really could not make these arguments. We really could not advance this cause without you, without your support. And so thank you very much for that. Thank you for being here. Thank you for your commitment to CRE, and thank you for your commitment to life. Because really that's what this is all about. That's what our mission is all about, and we're very grateful. But anyway, I think I've spoken enough. I think any questions about anything? Yeah, Caroline.
So why does it take so long between hearing in the court and deciding next time?
That's a good question. Yeah, part of that I think is I'm not sure I could fully answer, because a lot of that is tradition. They have done that as a matter of tradition, where they will hear arguments around this time in the fall, and the most controversial ones or the most significant decisions, they do not publish until June. And when I say publish, they have a written opinion, but also they will literally have somebody standing on the steps who will read this opinion. And so they do a lot of things by tradition, and that's part of it. But also that it does take some time, because you have a lot of give and take. Where I'm sure this opinion will be like many others, where you'll have a majority opinion, where one justice will author the opinion, and then he or she will be joined by others. But then someone or several others will have a concurring opinion, which means they agree with it, but they would put it in different language. And then you have others who dissent, and then even with them, they'll have another dissenter, but they put it in another way. So, and they're always looking at what the other person said, and so those things take time. And so in putting together these things, and they make sure it's absolutely perfect before it goes out. Yes, Sam.
Struck by how flat-footed the pro-choice counsel was by the questions from almost every justice that asked one, starting with Justice Thomas, and the Chief Justice said, is it 15 weeks long enough to make your choice? That was a pretty key question. And then the whole 5-voted thing, they said that Blackburn made up out of thin air to begin with. In 73, that there's no basis for that, and it changes. So I was greatly encouraged too. And if you haven't listened to the oral argument, it's riveting and fascinating, and it is available on multiple media sites. Listen to it. It's really amazing.
Yeah, it really is interesting. And yeah, as Sam brought up, Chief Justice Roberts hit on this. To it outside of the court opinion, and he said it was arbitrary. And you're right. The counsel for the abortion clinic really had no answers, and so she just started answering another question altogether. And so she would just a lot of times she would just sort of ignore the question and move on to something else. I don't know if that was very effective, but I think that's what she did a lot of times. Yes.
Counselor, I taught American government for 20 plus years at the secondary level, and to this day, I still cannot understand not only Roe versus Wade, but Ingle Vitale, Abington versus Shrimp, and the other Warren Court decisions that destroyed biblical truth in the public arena. How this got to the federal level at all? When, like you said, the Constitution is silent. The citizens, as Madison would say, of the several states voted through their elected representatives that life is precious. It's in the Declaration. How did this ever get to the federal level? Because this is a federal overreach if there ever was. Is it the 14th Amendment, perhaps someone?
Well, it's.
Can you repeat the question?
Sure. The question relates to not just Roe versus Wade, but other cases that came about in what's known as the Warren Court, which in there in the 60s and 70s, where you had a lot of activist decisions where it did seem like there were rulings that did not seem to have any basis in the Constitution. It really kind of goes back to there's a case called Marbury versus Madison, where the Supreme Court, that was the first, because this was not initially, at least it was not initially articulated. Perhaps it was initially conceived, but there's no articulation of it. But this is where Marbury versus Madison was, where the Supreme Court said that they could be the arbiter of what the Constitution says. And once they did that, they gave themselves a lot of power. And so once you can determine, well, this is what the Constitution says, then that's not really an issue if you're looking at the text and you say, well, this is what the text means. But it does become an issue, as happened with a lot of those cases, where the court really went further. And what it did was essentially create rights, such as a right to an abortion, that do not exist in the Constitution whatsoever. Yeah, Jim?
Nate, on the onset of Roe versus Wade in 73, what was the vote at that time, and what was the makeup of the court?
The makeup of it was, as I best recall, Jim, I think it was a 5-4 decision. It was a very close decision, and it was a makeup as far as political persuasion. It wasn't too terribly different than it is today. It was a case at the time that I don't know that many people really expected would happen. It was still something that, while there was some cultural momentum behind it, it was really the Supreme Court decision itself that made it in the cultural forefront. So it was, but I think what it reflects, Jim, is, and it go back to that question, is the extraordinary power that these Supreme Court justices have. If you can have 5 cobbled together, there's a lot they can do. Yeah, Craig?
These type cases ever make it? I think you said most of them just go in the trash can. What is the process of making it to the Supreme Court? How is that determined, and why were you so excited with this one?
Yeah, the question is dealing with how a case makes it to the Supreme Court level, because not all cases do, where you have a decision that it essentially goes to a district court level, and then you don't like the decision there, you have an automatic right to appeal, and you can appeal it to the appellate court, and that's based on geography, essentially. So you have like different gathering of states. Here, for instance, in the Sixth Circuit, which includes Ohio and Kentucky and Michigan. So we're in the Sixth Circuit in Tennessee. Mississippi is part of the Fifth Circuit Court of Appeals with Texas and Louisiana. So you appeal to that decision, but if you lose there, then you have to ask essentially the Supreme Court for permission, or you're asking them to agree to review your issue. Well, they get a lot of petitions. And so they are selective in what they take. And the percentages are, yes, 1% to 2% of the cases that are pursued are accepted. And so that's why I was very excited about this one, not only because the odds were so great, Craig, but also because the Supreme Court had not considered a case that could revisit Roe versus Wade in 30 years. 30 years.
So is that Robert's decision on whether to accept or not, or does that go before Paul?
That's a great question, and that was part of Craig's question as well. Yeah, how does that make? Well, it takes 4, and I've taken some informal tours of the Supreme Court where someone who really knows the place, they've walked me around and showed me. There's this like little table. It looks like a little kitchen table, and you have 9 justices sit there, and these cases come before them, and they basically decide right there, okay, do we have 4 justices who want to hear this thing? And so it wasn't just Chief Justice Roberts. I mean, it would take 4 justices who say yes. And there could be a lot of strategy involved with that. Sometimes a justice might like your position and really agree with you, but not accept your case because they're afraid you're going to lose it. Because they've sensed from the others, we don't have the votes here. I'm not going to vote for this court to accept it because I don't want that opinion to come out. And so that gives you some basis for encouragement, at least forethought that maybe something good could happen here. But here again, it's not a guarantee.
So if, I was reading an article on this, what I thought was really interesting, you don't hear much talked about, but how healthcare technology has really put the viability rule in place, and our ability now through technology to detect life, shortly after conception, and that's clinically, you can't argue that. It's not fuzzy logic, right? So that was really interesting. But if they come out in June and say, no, does this, what's the wave after that? It just goes to the states, and California can do what they want to do, and we can do what we want to do in Tennessee, and let the people drive that through legislation? Is that basically what will happen? Is you'll have battles in every state now to see where this lands?
Yeah. Did you get that question, Bill? Yeah. Those are great questions. As far as the fuzzy logic, well, actually in 1973 there's fuzzy technology. I think they had something that was a semblance of an ultrasound, but you really couldn't. It looked like almost how what the verbiage was when they talked to it as being a blob. That's sort of how it looked. But of course we know far better now. I remember Lori and I, with our last child, we had what was the 4D, and it's incredible what you can see. with that. And so there's just no denying it now. You say, no, that is a human being. And so yeah, I think that played a huge role. I think it played a huge role, and I think it played a huge role even culturally, because the percentages of women who see the ultrasound and then go forth for an abortion are very low. I mean, they're very low. But to answer your question, okay, what happens if the Supreme Court says, oh yeah, we're overruling Roe versus Wade, it's a bad decision? What happens then is that does not outlaw abortion. It doesn't. But it does put it in the hands of the people. It put it in the hands of Tennessee. What does Tennessee want to do? What does California want to do? What does New York want to do? And so, yeah, you will have some states that I think will outlaw it. I think you have some states that will heavily regulate it. I think you have some states there'll be no change. It'll be, you can have it up until delivery. And so it really depends on where you are and the jurisdiction. But at least that way, you would have a say-so. If you don't like how your legislator voted on that, well, then you can try to do something about it. But as it stands now, it's something that's dictated by the Supreme Court.